What's up, Dominators? Rico Garcia here. Today, we're going to be talking about litigation. Obviously, this is a term that a lot of people feel uncomfortable with, especially if you're a newer restorer, maybe you haven't had a tremendous amount of experience, or maybe you've been in the game for quite a while and just you've never really gone down the route of litigation. Today, in our legal corner, we are joined, as always, with our very own lawyer, Britt, that we're going to be talking about, all things litigation, how you should have your paperwork set up, and some of the best practices in order to make sure that you have a smooth process. So this is going to be a really exciting episode. Hope that you enjoy. Make sure that you pull out a pen, sheet of paper, take some notes. Lawyer Britt drops some really good knowledge bombs on this episode. So without further ado, let's jump right into the episode. Here we go.
Welcome to the Restoration Domination Podcast, where you learn actionable advice that moves the needle and helps service-based businesses dominate. Here's your host, Rico Garcia Jr.
All right. What up? So exciting. This is that time of the month again. We are at the legal corner with our very own Lawyer Britt. Lawyer Britt, how are you?
Oh, fantastic. As always. How are you, Rico?
That's amazing. So, so we've covered quite a few things in the legal corner. Today you wanted to talk about something special, something that I'm not the most versed in. So, and that's about litigation. And actually we're kind of talking off camera about how some companies may feel apprehensive about, going into litigation and what exactly that looks like, whether or not they're going to collect money. Do they have the right documentation? I think there's a lot that goes into it. And I think that there's not enough, even for me, there's not enough clarity about what that process genuinely looks like. So so let's talk about that. Let's take a deep dive and should people be frightened about, entering litigation, or should they be walking into each and every deal assuming the worst, or at least planning for the potential of it going to litigation? How does this process look like?
Right. And I mean, obviously, I am a lawyer who does litigation, so I'm going to be biased here, but I think that litigation is a great way to resolve a dispute that another party is not resolving with you outside of it, right? So if you can't get your bill paid in the normal claims process, sometimes your only option is to go into litigation. But I don't think we should be scared or apprehensive of litigation, because as the plaintiff, meaning the person who's suing the insurance company, or even as part of the plaintiff party. So if you reassign your AOB back to a homeowner and they're suing the insurance company, you're kind of in the driver's seat. So you determine kind of what happens. You're within the parameters of the court's procedures, if you will, but you're still in the driver's seat of what happens. You decide if the case settles or not. You decide if you continue with the case at any time. You can kind of dismiss your case if you get apprehensive, say, hey, this isn't working out, we can dismiss, but you're still in the driver's seat of hey, I can tell you when this ends. I can settle with you and go to trial. There's so many options. And at the very core, the point of litigation is to just gather information about your case, about the problem, so that you can potentially present that case to a jury and show them, hey, this is what happened, and here's why you should decide that I win this and that I get paid my money. And that's the overreaching whole point of any litigation, right? But our industry in property insurance, what happens is that most cases settle outside of going to trial. They may not settle right away. They may take a little bit of time to get through the litigation process, but they'll usually settle out, because typically, and I'm not saying in every case, but typically, when you are going to trial, you're giving up your right to decide what happens to six strangers, the jury. They decide what happens, right? So if you settle outside of that, you get to decide how much you're taking and what's going on, what the terms are, and what's going to happen in the end, right? How are you ending this litigation? Does that make sense?
Yeah, absolutely. So starting, at least in my mind, right? Regardless of what it is that I'm looking to do, I always try to start with the end in mind. So in order to do that in this kind of a situation, there's, first of all, what kind of a claim are you signing, right? What customer is it that you're dealing with? How does your paperwork look? So because you're dealing with a lot of litigation issues, is there a dollar figure? Is there a type of project? Is there what is the most common reason, if there is one, why deals go to litigation in the first place?
Typically, it's something that's wrong with the claim itself. So typically, the claim itself is not getting paid. The claim is underpaid or it's denied. And so in that case, the whole claim has to go to litigation to resolve a dispute. And that could be anything, right? There could be that the insurance company thinks that the damage is long term, or that there's some other exclusion in the policy, or that there's a named peril policy that doesn't cover certain damage, right? So if there's a dispute as the actual claim, you're not going to get paid, or you're not going to get paid your entire bill. So that's when really a case goes to litigation. But other issues that I've seen specifically dealing with restoration is that there's something wrong with the paperwork. So something's wrong with the direction to pay, something's wrong with the AOB. Somebody did an emergency services work and put it on a paper, but it was a year after the loss. Like something's wrong with the actual work that's being done. Those are the biggest issues when I see something going to lit. That's like, okay, we've got to, buckle down and get some information so we can build this claim up.
So now, is this an issue? And again, in your opinion, is this an issue, particularly with the paperwork, where it's user error for the most part, or restoration companies just being gun ho and rolling the dice and be like, well, maybe I'll get paid. I'll just put it up to lit. Do you see a lot of that mentality, or do you think that there's a lot of that mentality in the industry?
I don't even know if it's an intentional, like, we'll roll the dice. I think it's maybe somebody who's either not educated in what needs to be done and included, or somebody who is just like a doer, doing things too fast, not looking at the detail, right? Like, was this contract dated? Do we have the right estimate to it? Did we submit it on time to the carrier? Did we follow up with the carrier? Like those kind of things, little minute details, like, do we know what the date of loss is? Who is the insurance company? Do they have certain provisions we need to look out for? So I think the detail is like more important.
Right. So as far as like the overall price, right? Because again, most people, I'm assuming if they go to litigation, they're like, hey, look, sometimes I think that they're tripping over pennies on their ways to making dollars, right? Where it's like, their bill is, I don't know, it's just an arbitrary number. Let's call it 50 grand, and they've got an offer on the table for 48 and they're like, no, I want 50, right? So I'm sure you've probably seen quite a bit of that. And again, everybody has to make their own assessment as to whether or not that's a good strategic business move. Because again, a dollar today is not the same thing as $1 a year from now, right? There's this funny little thing called inflation, but hey, whatever, to each their own. How does litigation make sure that there's fair market value given to the contractor? And what kind of security does a contractor have by using litigation to say, hey, look, this is what my bill is, this is what we're worth? Or is there the flip side to that, or is there a rolling of the dice, if you will, of just the possibility of settling, for a much smaller figure?
So I don't think we should ever be rolling the dice, really. I think everything should be calculated. It's not really a game of chance or a gamble. We should be like looking at the facts to see, okay, what is the best way forward? Because yes, if you get an offer for 48 and the insurance company's digging their heels in and they're not offering you that 50,000, is it worth it to continue for another 6 months? We can. And I always tell clients, we can definitely we can move forward and hit them with all the discovery and prepare and do, pre-trial work and go to mediation. But at the end of the day, do you want to just cut your losses and be done? That doesn't happen as often, though, as, we see that there's something wrong with the claim itself. And so the restoration company is stuck kind of between a place where it's like, hey, there's actually not coverage for this, or there could be, but it's really a stretch of an argument for this entire claim, and you did work on it and you deserve to be paid for the work, but the insurance company's not going to pay for it. So we also run into that kind of issue. So those are where we see is like, okay, should you take less than what your invoice actually says? If so, why? Like, we have to have a reason why you're taking less. But on the flip side, if you have an accurate invoice and all of the items can be accounted for and the work was done properly, I don't see any reason why you shouldn't get paid for your invoice, for your bill.
Yeah. And I think that that's like the popular layman opinion, right? It's like, hey, well, I did the work. This is my invoice. Just go ahead, shut up and pay me. Right. But there's like so much more that goes into it, because then at the same token, you're like, hey, by the way, can you show me like, your picture file for how many pieces of equipment you had on the file? We're like, oh no, I lost it. Right. It's like, oh, wait, hold on. It's not like what you did, it's what you can prove that you did. Right. And vice versa. Right. So there's just that whole dynamic there. So kind of walk us through a, picture perfect type of litigation, if that's even a thing, right? From like, at what point should a contractor look at saying, hey, look, I'm having problems collecting from the insurance company. I think that we're at a point where we need to go ahead and start looking at litigation. What's typically the next step from there? And then the step after that, and so on and so forth, until there's a decision that's being made. Like, was there additional paperwork that needs to be gathered? Should all of this been done right from the beginning? Just kind of walk me through, like, color by numbers type of scenario.
Sure, yeah. And going off of your last point is that your file should always be prepared for any situation. So, like you're saying, have all your documentation, have all of your photos, have it organized and easy to access so that if an adjuster asks for it, you can say, yeah, here you go. Here's the work that I did. Here's the final product. Everything was signed off on. And it's easy for you to just get paid outright. But if you're facing a dispute, if the homeowners are not getting paid, then it's time to take the next step towards litigation. And usually with the restoration companies we work with, they're pretty organized and they have good relationships with their clients. And so if their clients are saying, hey, I don't know, we haven't heard back, or we haven't paid, or they won't pay for your invoice, then they know, okay, now it's time to bring Britt on. And then they call us and say, hey, we're having trouble with this claim. And I say, no problem, send over your whole file. And so I'll ask them to send over the entire file, because the more information we have, the easier it is for us to kind of pick apart story and then put it back together the way we want it and want to portray it. So we'll go through the whole claim file and say, okay, this is the issue. We'll send our letter of representation. We'll send our notice of intent to sue, depending on what response we get there, which is usually go screw yourself. Then we will go on to litigation and we'll file litigation and go through that process.
Right. Is there a traditional timeline that you would say, hey, look, Rico, if you've got issues collecting and you're at day X, you should really start thinking about what litigation may potentially look like? Is there like a recommended number on a calendar day that you say, hey, this is when you should be looking at the next step?
Well, I mean, just across the board, we work with restoration companies and public adjusters. We say, if something hasn't been paid in 90 days and there's no extenuating circumstances, or somebody didn't forget to get their invoice or their information to the adjuster, that's when you need to start looking at other options. Because at that point, it's like, hey, the insurance company clearly hasn't done what they're supposed to do in the time they're supposed to do it. So how much longer are you going to wait? I have people that'll come to me and say, oh, it's been 6 months. I'm like, well, why did we wait this long? We could have started this 3 months ago and already been moving on the case. Because the longer you delay in getting it to an attorney for litigation, the longer you're delaying getting paid. Because litigation, while it is effective, it's very effective at getting things resolved because you have access to other information to build a case. It's not necessarily fast. You could settle the case the first day you filed a lawsuit, or you could settle it right before trial. There's many things that happen. So I think the sooner and the more prepared you are, the better to get it moving if it needs to go to litigation.
Do you think that that's part of the issue, though? Like, how, again, when people think litigation, and again, you do litigation all day, every day. Like that's your bag. But like, for the regular contractor out there, like, they think of attorneys and how the system looks, and they've got this preconceived idea. It's like, well, okay, well, I'm 120 days now in, I'm still making calls to the insurance company. I'm trying to speak to the claims examiner. I'm trying to get all this stuff done. They're kind of dodging me, but I feel as if I was to go to litigation, that I'm not going to get paid forever. And they just kind of hold on to hopes and dreams of, well, maybe it's like right around the corner, I'll be able to go ahead and settle this thing themselves. Do you think that that's like a mental barrier of why more people don't go into litigation and try to get what they deserve? Do you think that that's part of the issue?
Yes, definitely. I've had plenty. I can't even tell you how many property owners, restoration companies, adjusters, and they, especially property owners, they believe in their insurance company and they want their insurance company to do the right thing. And so they'll try to give that company opportunity to do the right thing. But then a month goes by, 2 months goes by, and then they're calling again saying, I still haven't heard anything, let's move forward. And then we've lost out on 2 months. So yes, it's definitely a mental barrier. And I'm not saying to be trigger happy with litigation. Again, like I said, it's the next step to resolving a dispute between two parties, but it's sometimes necessary if you're not getting the kind of response and attention that your claim deserves.
Yeah. So the other part of this too is, we're talking about litigation primarily with the insurance companies, right? So, but there's this other element as well, which is the actual homeowner. There's a lot of restoration companies that will file for a lien on the property. Like if they're not immediately within, 30, 60, 90, 120 days, whatever the case may be, they're immediately filing for a lien on the homeowner and everything else. So instead of making the homeowner like an advocate for you in this battle against the insurance company, they're just saying, all right, cool, we'll just go after the homeowner and just call it a day. Is that a useful strategy? Is that the best strategy for a restoration contractor to collect their money? Or is there more strategic ways of having the same outcome?
Rico, I feel like you and I are the same in that we want to provide the best possible client experience so that we get referrals and great reviews and we grow a company that's making a great impact. And I don't see a connection between that goal and putting a lien against somebody's house because for most people, their house or their property is their biggest investment. It's their home, and someone's put a lien against it now. They can't sleep at night. If somebody, am I going to have to foreclose? I don't have the money to pay this. They panic, and now they've got a bad taste in their mouth. And we've had plenty of clients that come to us, homeowners, property owners, that'll say, "I don't want that restoration company to get a dime. Like we're not giving them anything out of this settlement. They put a lien against my home." And they just go off, right? And like eventually, yes, we get something to remove that lien because the clients don't want it there, the work was done, etc. But you're going to put a terrible taste in that homeowner's mouth. And I've seen this done once, just one time with one company where they explained to the homeowner, hey, we have to put this lien, but we're not going to act on it, blah, blah, blah. And the homeowner wasn't so worried about it. That's the only time I've ever seen that happen. Every other time, it's just they're pissed. They're rightfully pissed. But I understand that you obviously, as a restaurant company, you need to get paid, and that is a method of doing it. But it just becomes, what's your real goal here? Because there is retaliation, quote unquote, for putting a lien against somebody's house. Someone's going to be upset about that.
Yeah, right. So just creating raving fans. And again, like there's two sides to that, right? Because, you want to provide that like great experience for the homeowner or for the property owner. And, you want to do the right thing by them. But at the same time, you're like, man, like there's like a real cost to doing what we do. Like the moment that we get that phone call and you dispatch 2 trucks and 3 techs and plus the equipment, like there's real physical costs. And with the, I jokingly said something about inflation earlier, but at the rate of current inflation, like it's a lot of money, like fast. So the contractor's like, well, I need to make sure that I can get my money one way or another. Where I think that there's an issue is lack of communication. I think if you say, hey, listen, Mr. Homeowner, this is what the process looks like. Typically we file, a notice of commencement, and then we file for, the lien and all of this stuff. But this is the reason why is because, if the insurance company, whatever, like all of this, if you fabricate a story that's true, and that, the homeowner can get behind, it's okay, great. Then maybe you'll have that response. Where I think there's a lot of animosity is when all of a sudden out of the blue, they get a lien. It's like, whoa, what happened? You never said anything about it. Again, how should the contractor look at it? Because if the contractor is looking at it from the standpoint of, well, I could always just file a lien, is that the path of least resistance? Does that help the litigation process? When it comes down to insurance, like what role does that play in the big picture?
That role really just serves as exactly what you said. It's just protection so that the restoration company gets paid for their work. It does not help against the insurance company. The insurance companies do not care that there's a lien on the house. All they care about is their client and the policy and the case law that's out there. That's all the defense cares about. Sometimes that's all they have time to care about. I mean, a lot of these attorneys that we work with on the other side, they've got 150, 200, 250 cases, and it's a lot, and they don't care. They don't care about the single homeowner. And it's sad, but it's true. And so it doesn't do anything to push the case along, surely. And it usually pisses off the homeowner, like, except for that one instance that I spoke about earlier, where the client was what I assumed so well educated about the process and then trusted the company so much that when they put that lien there as protection, they didn't care. And they said, yeah, like, let's get that money paid too. And of course, I know you do a lot of cash work in your business. So there's always the option. Like if you're thinking 10 steps ahead here with somebody who's doing an insurance claim, you can present that to them as an option saying, hey, yeah, but if the insurance doesn't pay, you can pay cash, for our invoice and then recoup that from the insurance company. Because you don't need to technically wait, although that is common in our industry to do is to wait until the insurance company pays out the claim to get paid as well. But technically, you can get your invoice paid, and then the insured, the homeowner, the property owner, can then go get that invoice reimbursed to them by the insurance company as a cost.
Right. And one of the things that I find, and maybe we could talk about this and you can shed some light on it, I've always found it to almost help the homeowner when they have a cost incurred, where it's like no longer this, pie in the sky, like, we're kind of asking for permission for you to go ahead and pay these invoices. It's like, no, I've already taken this expense out of my pocket. Now go ahead and reimburse me. Have you noticed that creates a difference when it comes down to an argument with the responsiveness of an insurance carrier when there's an actual cost incurred?
It's more difficult for an adjuster to argue with something that's already been paid for versus somebody sending an invoice or a bill saying, this is what we need to be paid, here's our estimate. That adjuster's going through to cross out as many line items as possible, which I'm sure you've experienced, to try to reduce that bill. But if the homeowner has already paid, it's less likely they're going to do that. It depends on the pricing, right? They may try to say, well, that was too much that you paid, but is that really going to be a winning argument with the homeowner? No, they say, well, I already wrote a check for this, so it's money that I need reimbursed. I mean, we have clients that completely redo everything. They'll replace their roof and do all their restoration and be completely done, and we'll still be continuing with the claim to get them reimbursed. So it does happen, and it does make it, I don't want to say easier, but simpler to get reimbursed for that amount.
Do you think, and again, we understand that you're on the litigation side of things and you're not necessarily, the restoration contractor, but something that I've constantly said on the podcast, and I've really beat this dead horse, but I will continue beating it, is I believe that more restoration contractors should ask for the order. They should ask for money. And again, every situation is different. Some people simply do not have it. That's cool. I'm not saying to turn your back on them and not help them. I'm just saying, put it out there. Find out whether or not they have the financial wherewithal. Maybe they've got this amazing American Express and they want to use the points. Just ask for it, right? Do you think that that's an approach that more restoration companies should use? Number one, to just kind of offset their cash flow issues, right? But then also to legitimately create a better storyline for their customer that they care about in the event that it goes to litigation?
Short answer, yes. Long answer, definitely.
Short answer, yes. Long answer, definitely. There you go. You heard it first.
It does make it a simpler, more straightforward process for the property owner when they can say, hey, I had this loss, here's the damage, and then they go through with the restoration and with the repairs, and they can present invoices and saying, this is what I paid, this is what I think this is what my claim's worth. Pay it.
Right. Does partial payments, because again, I know that there's some people listening who's like, well, this is a $60,000 invoice. Like, my client doesn't have that kind of money. Cool, that's fine. Does partial invoice payments, or what you can call a deposit, essentially, does that carry the same kind of weight? Again, it just in my simple mind, it just shows, hey, look, this homeowner did everything humanly possible. They're already going out of pocket. They couldn't pay the whole thing, but they got the process started. Does that hold the same amount of weight when it comes down to litigation, or not really?
I think it's just bifurcated. So we've had that before, where there's like a small deposit, like somebody puts down $5,000 or $10,000, right, for a whole bunch of work that's done. And the insurance company, the opposing counsel, will normally treat that $5,000 or $10,000 as like, okay, cost incurred. And so when we're talking numbers, they're like, yeah, we got the $10,000 here and this and this and this. But they'll still try in a lot of circumstances to diminish that remaining amount. They'll be like, oh, and we'll say, yeah, well, we got the 30 that's still left on that invoice. And they'll say, well, is it really 30 or could it be 23? You know what I mean? And so it just kind of bifurcates the arguments.
Yeah, that makes sense. So talking about like pricing real quick, I mean, obviously there's a lot of concerns about like standardized pricing, and every business is slightly different. Every business has significantly different overhead expenses, right? So as you know, Xactimate, like that's kind of like the standard. Of course, you've got other like Symbility and stuff like that. How does like standardized pricing affect litigation? In other words, if people are going off of Xactimate and using their own price lists, or they've got, instead of 10 and 10 O&P, they're using like a 15 and 15 or a 20 and 20, like how much do those numbers affect the litigation process on the back end?
So I will always speak with the client first because it's exactly like you said. I'll always, well, the client and or the restoration company, if they're different first, because it's like you said, everybody's business is completely different. It's run completely different. There's different profit margins and costs and overhead. So I'll always speak with the client first to say, okay, what are we thinking for this invoice if there's a problem, or like, hey, this is what the invoice is. Here's what the offer is. Let's talk about what the offer is from the insurance company. So I'll always start there. It depends on the size of the loss and the size of your invoice, very, very truly, because sometimes the insurance company will say, hey, okay, yeah, like let's pay it if it's a smaller invoice. But if it's bigger, the insurance company might go ask somebody for a comparative estimate. And that person is going to use Xactimate or one of these softwares. So if your invoice is significantly different, i.e. a lot more than what their comparative is, they're going to try to fight it. And so then it becomes an issue of explaining, well, no, because this was done, or your comparative has the wrong X, Y, and Z. This line item's not right. There's more square footage here. It becomes a kind of a struggle to put them together. But usually, if somebody has an estimate that they can support, that we can move forward with that.
So you mentioned comparative estimates, which I'm actually really happy that you brought that up because comparative estimates, there's a lot of chatter in our industry about comparative estimates and whether or not they're acting as a public adjuster, especially here in the state of Florida, what gives them the right, to actually punch holes inside of your estimate. And also what are the advantages of you having, as an organization, you having your own comparative estimates? Because again, as I would hope that as restoration contractors, we should be somewhat of a tight-knit community. Like, yeah, sure, we can have a little bit of friendly competitiveness, but at the end of the day, like, you should know who your neighbor is. You should know Tom, the restoration guy down the street. And to have a comparative estimate almost in real time, I think that there's a legit advantage to that, and maybe even two, and be like, hey, look, this is my file. This is the job that we did. Do me a favor. Can you just go ahead and bang out some numbers for me? Let me know what you come up with. And is there an advantage because again, this happens all the time and we see it more and more. So if the insurance company is coming back to you with a comparative estimate, why don't more restoration contractors be like, I'm so glad that you gave me that, because here's and not like 2 weeks from that date, on the spot. Like, they send you a comparative estimate, you send them right back 2 comparative estimates that were done months prior or weeks prior, whatever the case may be. In your legal opinion, is that something that if you saw a company do that, would you be like, oh, this is nice, or that was utter waste of time?
I think it'd be great. I mean, I obviously, you don't want to be taking time out and expense and cost out if it's not necessary. But we do this with roofers actually pretty often, where the insurance company's fighting the roof, they get a comparative, and we'll say, okay, well, let's get more comparative. So we'll get companies to give quotes for the roof that our client is giving, and so we'll do that a lot with roofers. It is helpful because it shows that the comparative the insurance company may be using either like isn't the correct pricing, or is just like not up to date with what's in the industry in this area. So I think that would be a fantastic idea.
Yeah. And unfortunately, I just don't see that happening enough, but there's definitely, and again, this is on all sides, right? Roofing for sure, but even down from remediation to mitigation, like the power of using your own comparative estimates is available to you. And again, there's no reason, I would say, as a restoration contractor, for you to even accept the insurance company. Again, like, think about who's feeding who. The insurance company is feeding this company to do a comparative estimate. Right off the bat that they're not going to be like, well, I got to make sure that I put every single line item in there. I got to make sure that this is going to be substantially, like, they're not going to do that. Like, I've never gotten a comparative estimate that's been higher than like the one that we submit. Like, not once, not once. Like, if you think about that, like, that seems like, the scale is a little off here. Right. So like, for you to go ahead and again, I want to make this very clear, making sure that it's legit, that it's above board, that there is no like, hey, by the way, my estimate's at this, I'd like for it to be hot. Like, no, just like, hey, look, here's a picture file. These are the measurements. This is the equipment that we had. Let me know what you come up with, and just get a legit comparative estimate. I think that would hold a lot of weight in the event of, it going to litigation, because now it's like, okay, great. Well, you've got your number. We've got our numbers, and we're fair. Like, I think that would be
Yeah,
an amazing argument.
I think so too. I think what would be even more interesting is, not only getting a comparative from an actual company in your area, but even possibly reaching out to a company that does comparatives for insurance companies. Maybe not the same one that your carrier in that claim is using, but another one, and seeing what they come up with. Hey, here's the picture file and all the information. Give me what you would,
Give me what you got.
give me what you got, what you really think, right?
Right.
And if it's coming from a company, you would think that estimator would be a little more apt to include and be a little more meticulous about line items and actual information. So that would be interesting as well.
How interesting would that be? I mean, that'd be really epic. Like, like if you use the exact same one, like if you beat because there's only a few of them that, at least there's a few of them that you will see constantly over and over and over again, right? From the same company. If you beat the insurance company to the punch, be like, hey, this is the picture file, boom, you get a comparative estimate. All of a sudden, the insurance company, a couple of weeks later, they send their estimate, and all of a sudden it's ridiculously off. Like, talk about having like bias, right? And I'm sure it would totally happen, like 100%.
Yeah, it would. I feel like that'd be great.
I don't know. I think I'm gonna have to do that now. Just for shits and giggles, just to find out what's going on. But so as far as the litigation process, like what else do we need to know? Like what else should we really keep in mind that we should keep on the forefront of our mind? How should we educate our customers, our clients about what this process looks like? Like what else? Like if you had like a step-by-step playbook and you were really coaching me through the possibilities of what this should look like for us to have the best possible outcome, what else should we do?
So, I mean, obviously, restoration people are not lawyers, or at least I think most of them are not. So you can only tell your clients so much. But I would start with the fact that everybody seems very apprehensive and cautious about litigation. But like I said in the beginning, in reality, it's just a way for you to gather information to build a case to show possibly a jury, but possibly the other side, why you should win, why they should pay whatever you're asking them to pay. And so the way we do that is through discovery. So the crux of litigation is going to be discovery, which is just like exactly what it sounds like, discovering information. But you have access to documents and people and testimony that you don't have access to any other way. Like in the claims process, you can't just call up the field adjuster most times and just say, hey, did you really see this damage? Or, did you really look at this thing? Did you forget this here in this line item? Who did you talk to? What was said? Did your supervisor tell you not to pay that? You can't just call them up and ask them that. They're not going to tell you the answers, and it's just not going to be beneficial. But in a deposition, on the other hand, when they're under oath and you're asking them questions, they have to actually answer truthfully. So that's a way for you to gather better information that really pumps up your case more so than what information you have in the claims process. Because the claims process is really just you as the restoration company or as the homeowner or as the property owner giving information to the insurance company about what happened and why you should be paid. So when we get into litigation, we're building our own case. And so we get the information from the carrier to start saying, hey, this is what actually happened and you should have paid this and there was bad faith here. And we're building up that story to possibly present to a jury. But like I said, most cases don't go to a jury. So you're really building up that case to go back to the carrier, to go back to opposing counsel and tell them, hey, here's why you're going to lose. So let's settle this out now.
Right.
And that's really the crux of litigation.
Yeah. And something that you mentioned on another legal corner was, I think you had mentioned a story about you being in a deposition and where, an inspector, an adjuster basically went out and was like, I don't know, a couple of minutes up in the attic. And supposedly like they said that they were up there for however long it takes. And again, I think that's an important factor, right? Like starting with the end in mind, saying, hey, look, this is just understanding like while you're there. And if you're meeting a field adjuster, to take like accurate notes, right? Take accurate notes. And because you're never going to know if that's going to be useful information or not. Right. And I think that not enough people are actually looking at it that way. They're like, oh, it'll probably, again, because I think we're all a little optimistic, like, oh, everything will be just fine. Seems like a really cool person. Right. But these are the details that could potentially win during litigation. So when a restoration contractor is out in the field and they're meeting field adjusters, like should there be a certain lens in which they're looking at how this adjuster is acting, what notes they're taking? What should the restoration contractor look for?
Honestly, it's so difficult to discern anything from meeting that field adjuster as to what the outcome is going to be, because you can meet the friendliest adjuster in the world and they don't have any authority. They're just there to take pictures and measurements. And then they go back to their supervisor and the supervisor actually makes a decision and you never met that person and they never saw anything. So it's not always a good indication, but I think it's always a good idea to take notes exactly for that story that I told you last time, where the adjuster was literally in the attic for like 2 minutes. And they tried to tell me later on in the deposition, oh yeah, I usually go up there for an hour and a half, or a half hour. And that was just not the case. So those little details where you can say, hey, this guy denied the roof, but he only stood on a ladder, or something like that, where you see the little details, those are helpful later on. But I don't know that you're going to glean a ton from the actual field adjuster inspection, because you never know if that person has authority or not. You never know. They could be super nice to your face and then later on say, no, this is all denied. So not a ton that you're going to glean, but it's good for you to just be observant and take notes.
That's awesome. So short and sweet of it is, don't be scared of litigation. Use it as a tool. Getting your paperwork, and again, it's something that we speak about all the time, but we take it for granted, is getting good quality paperwork, getting good quality pictures. Invest in technology, invest in software that's going to help you document things better, like Company Cam, Partial, like your Matterports, like all of this stuff that, may seem like overkill, all of this stuff that may seem a little daunting to, especially for the smaller organizations out there. All of this documentation is ultimately going to help you have a much better outcome. Hopefully never get to litigation, but in the event that it goes to litigation, right? You've got all of your ducks in a row and you know that the opposite side probably isn't. So you want to give yourself that winning shot, right?
Exactly. That's exactly it. I mean, always thinking 10 steps ahead. That's all. We're always thinking 10 steps ahead. Like when I'm filing a lawsuit, I'm already thinking about all the discovery that we need to get, who we're deposing, what we're asking them, like what's going to be said at the mediation. Like we're already planning out everything. So if you can plan from the first time you step on in that property, what you're going to have in your file, how it's going to be set up, how you're contacting them, when your follow-up time is, you're already setting yourself up with all the documentation and the notes and everything that you could just literally plop over to an attorney if things go south. And then you don't have to do anything differently. You're not stuck running back to the file or saying, oh, I don't have the proper photos and X, Y, and Z. You could just say, hey, there's an issue here. Attorney, please handle it.
That's awesome. So again, Restoration Nation, I would say if you've ever been apprehensive about going the litigation route, or if you got any additional questions about how this process looks for you in a particular case, then look, there's contact information in the video description below, in the show notes as well. Just click the link, give our very own lawyer Britt a call, and she's going to go ahead and walk you through the entire process. And again, it's a tool to use. It probably shouldn't be the very first thing that you do, right? Even the attorneys will tell you that. But, take the action, find out, educate yourself. Litigation, even for me, has always been one of those things where I'm like, I don't really know, right? But a lot of that stems from not knowing what lies down the road. So really getting comfortable with the process, understanding what your rights are as a contractor and what you need to do in order to win is uberly important. And outside of that, any closing remarks?
Yeah. And I would say, as a follow-up to that, you could use me as a resource. There are plenty of restoration companies who will call us and they may not know that something needs to go to litigation, but they'll say, hey, I'm having this problem. What are you thinking? What should we do? And I'll be the first to say if you need us or not, if you need to go to litigation, what's going to happen next. If I think, hey, you can actually try this route first and see if it works, I'll tell you that. And if it does, fantastic. Now you're resolved without ever having to go to litigation. So you can use me, attorneys as a resource to say, hey, what do I do here? What are you thinking? I'll, brainstorm a solution. And it may not be litigation. It may be, but it may not be. And then you have a course of action.
You got it. So Restoration Dominators, make sure that you check out the link below. Shoot your girl a call. Brittany Alexander, lawyer Britt, the one and only, always joining us and giving us fire here on the Legal Corner. And remember, as always, hustle, hack, dominate. Let's go.
You've been listening to Restoration Domination, your #1 resource for tips, tricks, and hacks to help your business grow. Subscribe to our channel and follow us for more restoration domination. And follow our host at Rico Garcia Jr. on Facebook, Instagram, TikTok, and LinkedIn. Till next time, this is Restoration Domination. Hustle, hack, dominate.